Let us pray. Almighty God, who in your wisdom and goodness have appointed the office of leaders and parliaments for the welfare of society and the just government of the people, we beseech you to behold with your abundant favor as your servants whom you have been pleased to call to the performance of important trusts in this republic. Let your blessings descend upon us here assembled, and grant that we treat and consider all matters that shall come under our deliberation in so just and faithful a manner as to promote your honor and glory, and to advance the peace, prosperity, and welfare of our country and of those whose interests are committed to our church. Amen. We can commence.
Order number 1, administration of oath. Order number 2, communication from the chair. Order number 3, messages. Order number 4, petitions. Order number 5, notices of motion. Order number 7, questions and statements. Sorry, order number 5 is papers. Order number 6, notices of motion. Order number 7, questions and statements. Order number 8, the Constitution of Kenya Amendment Bill 2020, second reading. Resumption of debate.
The Chair, Departmental Committee on Justice and Legal Affairs.
Thank you, Mr. Speaker. I would like to start with Mr. Speaker, and I register my congratulations to His Excellency, the President, and Amuse Baba for the great ingenuity involved in the crafting and the process through BBI task force to this very first popular initiative bill under Article 257. I would like straight away to dispel any illusions that there is a mix in the format or a tenor or effect between Articles 256 and 257. This bill, the one before this House, is exclusively under the provisions of Article 257, exclusively. And it is being formulated pursuant to the sovereign authority under Article 1 of the Constitution. Article 1 provides that all sovereign power belongs to the people of Kenya. And for my reference, let me refer to them by the acronym WAJICO. The use of the word sovereign in this article is not accidental. It is intended to bear some impact. The people exercises that sovereignty and do it either by themselves directly. That is why the article says directly or through their elected representatives. Here, we are dealing with the direct exercise of authority. Mr. Speaker, I have looked at the definition of sovereignty and sovereign. There is a very leading dictionary called Black's Law Dictionary. And it's in its definition, it is also in line with another authority, very authoritative journal called Cornell Law School, Legal Information Institute. And both surmise sovereignty as a political concept that refers to dominant, I'd append the word dominant power or a supreme authority. The whole of that is respectively underpinned. It goes on, the sovereign, now not sovereignty, the sovereign is the one who exercises power without limitation. Without limitation. That means when the people of Kenya exercise authority to formulate a bill under 257, they have no limitations for whatsoever. The ordinary dictionary, Oxford, concise, also is in accord with that definition. It says, it defines sovereignty as supreme power, supreme or authority. Then it goes further, and this is important. Sovereign is defined as the supreme ruler. That is why in places like England, the Queen is referred to as sovereign. Here, Wajiko is the sovereign. Article 1 is couched in a manner that has alternative. The alternative is the exercise of power through an institution like ours, this House, pursuant to 256. Mr. Speaker, the phraseology is disjunctive. Direct or indirect, they are not the same. It is not direct and indirect. It is direct or direct. Those are two. So here we are on the first phase, direct exercise of Wajiko's sovereign authority. This House, therefore, and I say this unequivocally, this House, this chamber, has no power to amend or alter the bill in its present form in any way. In effect, it does not even have the residual power that everybody calls inherent, to amend or interfere with the structure or the architecture. Let us not miss and start talking about the schedule, 87, 89, no. 92, no, you have no power. If Wajiko predicted or intended the House to have power to amend, nothing would have been easier to expressly say so. Wajiko would have said that.
Put the question.
Article 257, therefore, is exclusive and self-regulatory. You may think that there is a lacuna. That is the intention of Wajiko. There is no lacuna as far as Wajiko is concerned. I looked at inherent. Inherent is what we call sometimes the wild horse, the unruly horse. And but here, I can't see even any verse or any place for inherent authority. As an institution, sir, created by Wajiko, as I have said, we, as Wajiko's servants, inclusive this House, is a servant creature of Wajiko. We have a singular and joint and noble duty to scrupulously and jealously guard against the interception of Wajiko's initiative. Her wish is independent, and she has the sole authority. Again, sir, I emphasize, without apologies for repetition, we cannot amend the bill in its present form or the substance thereof. And the bill remains intact as transmitted to us by the county speakers through by way of certifications. And we must, whether we pass it or not, transmit it wholesome for the people, refer for people to hold referendum on it. In fact, is to ensure that what was brought forward is the same that goes again to the people, and then when we have majority, then the referendum is carried. I must emphasize here, however, that there may be errors. Errors or misdescription. 87, sub-article 7 being called 89, sub-article 4. Or a cabinet secretary being referred to as cabinet minister. These are not material. These are not material. They don't change the tenor of what Wajiko intended to say. They don't go to the root. You, as our speaker here, or the Attorney General under the revision of laws, you perhaps understanding wonders, I am not certain on it. I leave it to you. You have general powers, inherent powers, to help this House and bills, because this is a case of a ruse by another name. These are errors that are apparent, what we call in law, errors apparent on record, drawing an analogy. These are errors that are apparent on the face of the bill. They don't go to the root of the substance or the intention of Wajiko, so long as we don't kill that intention. These are superficial errors that do not affect the tenor of the bill. In our noble calling, we, as members of this august House and leaders in this country, we must live by example. And we are singularly and jointly and constitutionally enjoined to invoke, implement, and protect the concept of national values and the principles of governance as set out in Article 10. We must adhere to the ethos pertinent thereto. We must be objective and not subjective to ulterior political considerations or interests or leanings when we are dealing with this bill. We should not create sideshows or trivialize this bill. what I saw with respect yesterday were some disruptive matters that do not relate to the tendencies. The Ntuli had nothing to do with this house. He is in the other house, in the other chamber. I am insinuating that if you don't care about national interests, then you have no place with a lot of respect in this house. Because this house is created by Wanjiku, and Wanjiku tells us to live value in Article 10. Because you have a weapon there. I don't have, Mr. Speaker, I don't want to set out what is set out in Article 10, extenso, but we are state officers. Therefore, we are bound by those ethos. Each one of us is familiar with the ethos that we must apply that objectivity in interpreting the Constitution and passing our laws. Good faith must obtain in enacting, applying, or interpreting the law. And again, you can't sever this from public policy. The national values, one of them talks about patriotism. Patriotism, national unity, sharing, the rule of law, democracy, participation of the people. We cannot allow, because Ruiru with 500 people is given a constituency, 2 constituencies, 500. I'm giving an example, 500,000 represented by 1 constituency, by 1 member of parliament here, Mheshimiwa King'ara. Tharaka, Nidi, where my as well learned Fred George is 400,000 people. It is represented by 3 members of parliament. I'm just giving that by way of example. I'm talking about population, not trees, not area. He can talk about the state himself. Now, that is the sort of inequity that we are trying to stabilize. If we find that that is not satisfactory for any party, then resort to 256. Bring an amendment. Again, I say, bring an amendment at 256. In any case, when we are talking about the schedule being placed there or there, let me again say this. If you look at 89, Article 89, 1, it says in mandatory, it is couched in mandatory terms, there shall be 280 constituencies. Therefore, IBC has no authority or jurisdiction to bring to 291 or bring it down to 270. If you look, even the wording, the name IBC says is independent, electoral, and boundaryless, not constituencies, not creating constituencies. The word constituency is not included in that name because therefore of constituencies, because sir, it meant and it is intended that they do not create, they can only change after the 30 years the name or the boundaries, not add or deduct Now that Wajiko has decided, Wajiko, whether it is a village, whether it is here, it is Wajiko's decision. Wajiko can even remove you from this house. Wajiko can say, and I don't want that to happen, can say that people with disability, now we are removing that, we want everybody to compete. Wajiko can say that. We must equally, sir, we must equally, again, I want to remind my friends, yes, Crutch, my friend, I think now, if, Mr. Speaker, you can protect me from another detractor here. I think he doesn't want me to make my point. Is what I was talking, the type I was talking of yesterday. With a lot of respect to Sankok. We must also be mindful of the chapter 6, sir, that the considerations we must have is the mandate we have been bestowed to us by Wajiko. Sir,
Speaker, sir. Don't forget Speaker.
Yes, Mr. Speaker, sir. If we do what some parties are thinking, that we can amend the Constitution, we'll be subjugating Wajiko to an inferior role when we are told she is the supreme authority. We will be attempting, that would be an attempt in vain, in effect, to reign on Wajiko by substituting her wishes with ours. We cannot do this. This, again in vain, is coming to us in all forms under the guise of pursuit of other political, extraneous, irrelevant matters to the bill. Any such schemes are ill-motivated and an affront to Wajiko's sovereignty and to the nation, therefore to the nation and the people of Kenya. Such destructive overtures, their intended beneficiaries or sponsors are bound to fail. We are therefore, let us guard against becoming busybodies vis-a-vis our duty here to implement Wajiko's wish. I want to set out a few. I have already spoken, sir. Mr. Speaker, sir, I have spoken about the Shendu. And I said again, I repeat, even gleaning, even when you simply glean from the provision, the word itself excludes creation of constituencies. Whether Wajiko creates them under the Shendu or as paragraph 1, that is her wish. Now, sir, Mr. Speaker, sir, I want to comment on the institution called Ombudsman. This will be comparing our jurisdiction. It is, that institution is widely accepted in the biggest democracy in the Commonwealth, in the world. India. In effect, in India, it extends, it goes further. It includes even private corporations. They are enforced to have ombudsman. Many European nations, Sweden and many others, have discovered that this is the thing. We must not kid it. Indeed, even us as a legislature, we have ombudsman. The people of Kenya are the ones who watch us. You will not come back if you do this or the other. We want to remove you. That is the institution, the people of the constituency and people of Kenya. They are the ones that supervise us. When you go to the executive, again with the respect, my learned vice chair, I think he was the first or was in that institution himself, in an institution called Ombudsman. I also want to say, no amendment pursuant to Article 257 can be said to be unconstitutional. There is nothing unconstitutional with Wajiko. And enjoying her power, exercising her power, you can't say she's being unconstitutional. Even if you say the courts will do it, the courts under Wajiko are created by Wajiko. I will say, if you ask me, and please ask me through the speaker, I said again, don't keep on detracting me. His Excellency President Uhuru is a person. Baba is a person. Is also Wajiko included in that name. If you try to detract us by saying, oh, they use money, listen. Money belongs to Wajiko. All the money, in effect, Wajiko can do what she wants with her money. There is an auditor general, there is even to audit the use of money by Wajiko's agents. When you come, it's not a sanction that Wajiko is limited. In effect, if you read the constitutional history of the American people, the word constitution comes from money, the use of money. Right? If you read the history of the American people, the constitution, the modern Republican constitution, it is formed because of the use of money. Wajiko is the one who authorizes whether Honorable Sankok or Kigano or anybody to use money. And there is an audit for it. So we can't have this side show, oh, money was used or that was done. No. Wajiko can do nothing illegal in this country. Mr. Speaker, sir, before I end, we filed and laid a report here. I agree with that report. Though there is a dissent, the joint committees were united in its approach to the mandate that we entrusted, this House entrusted to us, and dealt, for the sake of simplicity, I think I've lifted a page from the report, which is worthwhile. It contains the issues that the committee dealt with. And if you look at these issues, I'll be requesting the clerk through you, Mr. Speaker, for the sake of anybody who wants to contribute, to look at the issues that are contained, the genesis of the issues that are covered by that huge report. It is the issues, all the issues are spelled, and also that
Additional 1 minute. Please, just check. The yellow shows that you have 1 minute.
Yes.
The red shows that you have 30 seconds. So please.
You give me that thanks, to thank the House for listening to me and my colleague for extending some destructive, and I think he has kept quiet now. Thank you. Thank you very much. I beg.
Very well. Can I get the Vice Chair? 15 minutes for any other person, any other member speaking, please. Remember that.
Thank you, Mr. Speaker, and thank you for this opportunity to support the bill as moved and as elucidated by the chair. Mr. Speaker, for the 15 minutes, can I remove this mask?
Yes.
Thank you. Thank you. Mr. Speaker, from the outset, it is important to point out, if the consultation could reduce, that the ultimate recommendation of this report is that both houses approve the bill without amendments. And that is in page 169. It is true that there are members who may have spoken prematurely on this, not knowing the conclusion of this report. The report does not recommend any amendments to any part, and I will explain. Mr. Speaker, we were unanimous on the 32 issues that the chairman has spoken to, except one on which there was a divergence of opinion, and what we did in good conscience was to include both shades of opinion, and they're both in the report. But Mr. Speaker, what we did is that in the course of these consultations, we did identify some minor typos, and I will speak in terms of how they are dealt with. It is the role of any committee that is tasked with such work to identify what could be pitfalls in the journey. That we did. If you are irresponsible, you ignore them, hoping no one will notice. And sometimes it has disastrous consequences. But if you are responsible, you identify them and see how to resolve them. If you read the entirety of this report, where we have identified pitfalls, we have suggested how you overcome them. Now, that is what some people misunderstand and think it is sabotaging the report and the process. That is actually facilitative, not disruptive. It is to protect this document from any possible flounder thereafter. Mr. Speaker, especially if one reads the report completely, you will see, and I will come back to this, that at the end, there are only 6 minor areas, and they're on page 99 of this report. Minor areas of typos. 2 of them, we decided that we cannot touch because they would require us to put ourselves in the place of the promoters. We cannot substitute ourselves for the intention of the promoters. The other 4, in the bill before us, you will see that 3 of them are actually not in this bill. There's only one, and I will speak to it, and it is quite minor. So I also want to let people know that there are no major issues in terms of inconsistencies or typos, as may have appeared. The fact that we identified them does not magnify them, and they're very easy to deal with. Mr. Speaker, I want to assure the nation and this House that the committee was unanimous on all 31 issues, and there was no division between the Senate and the National Assembly at all throughout our deliberations. And you will see in the signature page that it is signed across the board. Mr. Speaker, we were agreed, and even after consulting with the experts, that this is a popular initiative under Article 257. The question of who initiates it is irrelevant to whether it's popular or not, because we agreed that in all the countries where you have popular initiative, it is an additional measure constitutional amendments usually could be proposed by Parliament or by the executive. Popular initiative gives any other person the opportunity, but does not exclude the first two. Even this Parliament can choose to initiate an amendment by popular initiative rather than inside this House. So the issue that the executive may have initiated does not take away from the fact that it's popular initiative. Mr. Speaker, we agreed that while the role of Parliament is restricted, it is not ceremonial. It is not ceremonial because if you look at Article 94(1) and 94(3), you will see that Parliament is the sieve through which anything that becomes law in this country must come. Parliament is restricted when it's popular initiative, but it is not ceremonial. And I will explain that a little more. Mr. Speaker, Parliament cannot substitute its views for the views of the promoters. And therefore, Parliament cannot make any substantive change to a document that has come through popular initiative. But, Mr. Speaker, Parliament, on a close reading of Article 94(1) and 3, has that inherent authority to make any errors, to correct any errors of form or typo which are consistent with the intention of the promoters, which does not substitute the intention of the promoters. So if the promoter meant Article 89(7) and it reads 87(7), which does not exist, Parliament can, in its discretion, correct that. But as to whether we choose or not, that is for us. And it depends on whether that typo has any grave legal consequences. And as I'll show later, in our case, it doesn't. Mr. Speaker, we agreed unanimously that in this process, a referendum is a must. And this document must be taken to the people in a referendum. That is agreed. Mr. Speaker, we also agreed that public participation is not perfunctory. It is not salutary. It is substantive. It is substantive first because it is a constitutional requirement. If we do not do it, then the process is in danger of nullification. It is also necessary, Mr. Speaker, because it helps us identify some of those gaps and how to deal with them, as we have. But more importantly also, it helps us make up our mind whether we want to vote yes or no. It helps the country make up their mind whether they want to vote yes or no. We did examine some very specific issues which have been raised as unconstitutional. One is the question of the judiciary ombudsman. Two is the question of removal of vetting of ministers and PSS. Three is the question of regulation of professional fees. And four is the question of the manner in which the two-thirds gender principle has been put in the Constitution. I'm happy to tell you, Mr. Speaker, and this House, that after thorough examination, and you'll see that in the report, and even after engagement with the experts we had engaged with, we came to a unanimous conclusion that none of those provisions are unconstitutional. Some people might find them undesirable, but undesirability and constitutionality are two different things. As long as it's constitutional, if the people agree with it, then it is okay. Mr. Speaker, I want to say this, and I want to say it categorically, and this is where the one issue arises, constitutionality. Mr. Speaker, as a matter of law, and this is where I disagree with my chairman, a constitutional amendment can be unconstitutional in two ways. It can be unconstitutional if it does not follow the process that is already in the current constitution before it's amended. Or it can be unconstitutional because it results in something that does not accord with constitutionalism. Mr. Speaker, if today there was a popular initiative that suggests that we must exterminate one of the 43 ethnicities in this country, as happened in the Holocaust and elsewhere, it would be unconstitutional, even if it came through this House and was adopted, because in substance it's unconstitutional. Or in this House, if today we decided that the presidency will only rotate in one ethnic group, it would result in that. I'm not speaking to the document yet, I'm speaking to the theory. Constitutional scholars agree that you can have a constitutional amendment that is unconstitutional. Now, what we have done, and professors of law like John Buddy is saying it's not true, but that is okay, because that is your view. I am talking about the law. John Buddy, you've not stepped in law school, so just allow me. Now, the thing, in our case, there were issues that were raised. In our case, there were issues that were raised about fairness of Schedule 2. There were issues that were raised about constitutionality. There were issues that were raised about completeness. I will not speak to them because they're in the document. But to be fair, because there are equally members, including lawyers, who do not agree with me, and they're entitled, because in law, there's no strict answer to anything. There are lawyers who believe that no constitutional amendment can be unconstitutional. What we have done, Mr. Speaker, and that was the midway path, we put the view on constitutionality and the view on unconstitutionality. But what we didn't do, there was a serious push by some of the members of the committee to suggest that we sever Schedule 2 and remove it. But we were all agreed that because Schedule 2 is part of the document, and we had agreed that we cannot make substantive changes to the document, it must go with the document. And therefore, what it has done is that it has given members of this House the opportunity to look at it and make up their mind. But what's important is, it is merely an observation. It has nothing to do with the document itself. For the document must go as it is. As I'm closing, Mr. Chairman, Mr. Speaker, and this is my last point, the minor errors. Mr. Speaker, I'll urge members to look at page 99 of the document, where we identify some of the what we call minor errors and typos. Ultimately, Mr. Speaker, looking at that list, there is only one typo in the bill that we are considering, and that is in respect of clause 51. Clause 51, Mr. Speaker, refers to Article 204. The only thing it does not do is indicate that it's looking at 204 sub-article 6. So we have two options. We can either exercise that jurisdiction here and just insert the word sub-article 6, or we can leave it. I want to submit, Mr. Speaker, that whether we exercise it or leave it is of not much consequence. Because even if we don't change it, the very constitution that we have encourages a purposive interpretation of the Constitution. Anyone looking at this amendment will see that what was intended to be amended was Article 204(6). So even if we don't invoke that jurisdiction that we have for correcting typos, form and error, it is of no consequence. Because any interpretation, because it's very clear, because it talks of the sunset clause, in the entire 204, no other sub-article talks of the sunset clause. So I want to submit, Mr. Speaker, that it is perfectly in order to pass the document without any amendment, because any typo is inconsequential anyway. Mr. Speaker, with that, I want to go to the words as appearing the recommendation of the entire committee, which is unanimous on page 169, that having considered the Constitution of Kenya Amendment Bill 2020 and the submissions received, the joint committees recommend that the Constitution, that this National Assembly and the Senate pass and approve the bill. And in addition, which is the second one, that Parliament enacts legislation to provide a framework on the processing of a bill to amend the Constitution by popular initiative subsequently. Thank you, Mr. Speaker.
Very well. Just perhaps I think maybe Honorable Tilly Amolo, maybe many people may have forgotten that you are a member of the committee of experts that came up with the current constitution, in which when you look at, there's an article that I think every member should always have it at the back of their mind, Article 103, about how a member may lose their seat. If you look at Article 103 of the current Constitution, there is sub-Article 1, with many paragraphs, A, B, C, D, et al. Thereafter, clause 3. Anybody, that's the point that the Honorable Otiende Amolo is talking about, the purpose. If you are to look at that article, would you say Article 1 or 3, would you talk about clause 2? Because it doesn't exist in the, you just look at that. Look at that article. It's not clause 2. It jumps to clause 3. But it was passed. It was passed as it is the Constitution of Kenya, which was promulgated. I think it's important that for people to understand some of the issues that the Honorable Otiende Amolo was speaking to. That some of them may be inconsequential. They don't have much import, even if they are led to stay as they are. Now, because honourable members, we agree that we will have everybody who cares or desires to speak to this bill. I will now not use the normal left of Mr. Speaker and right of Mr. Speaker, because I'm looking at the requests. There are 54 in number, and I think my screen shows the first 16. All of them appear to be from the left of Mr. Speaker. So, you know, the early bird catches the worm, isn't it? First come, first served. So don't. I'm announcing this so that nobody says, why are you giving people only one side? It is the way the screen is. Now they have increased to 57. Yeah, because, I mean, let's be fair. Let's just give people the way they put in their requests. What do you mean, error? But the Honorable Pukosa says he was among the first to come. Yet when we are counting to see whether we have quorum, he just walked in. But there were others who had put in their cards earlier. That's what it means. Honourable member, so that it's good to announce this so that we know why it is that. So the first one on the list is the member for West Mugirango, the Honourable Kamosi.
Yes, thank you, Honorable Speaker. I came here, the first one this morning. And Honorable Speaker, I've had opportunity to look at the report in entirety. And Honorable Speaker, right from the beginning, I want to make it very clear that there are some proposed amendments which I really agree with.
Honorable Kekaria, it is never done that way. You can't move from there. You have suddenly forgotten you are already in the house.
And there are some proposed amendments, Your Honorable Speaker, which I do not agree with. Honorable Speaker, in clause 5 of the bill, it proposes to amend Article 31 of the Constitution on privacy to include the right of people not to have their personal data infringed, Honorable Speaker. This provision, Honorable Speaker, is a good provision because it will protect the privacy of the people of Kenya from their data being infringed, Honorable Speaker. Recently, Honorable Speaker, we have had the Huduma number, whose data is being stored by the government. This provision, Honorable Speaker, will go hand in hand to protect the privacy of the said data. Honorable Speaker, clause 6 of the bill seeks to amend Article 8 of the Constitution to provide for expeditious investigation, prosecution, and trial of corruption cases. This particular proposal, Honorable Speaker, it provides that under the Constitution, this House can enact a legislation to provide for expeditious trial of the corruption cases. In my view, Honorable Speaker, this particular provision or proposal can as well be captured in the ordinary legislation or statute without providing the same under the Constitution of Kenya, Honorable Speaker. Honorable Speaker, in clause 9 of the bill, it proposes to amend Article 88 of the Constitution to mandate IPC to ensure no more than 2/3 of the candidates of a political party are of the same gender, Honorable Speaker. This provision, in my mind, it serves the right purpose, that it will go all along to solve the issue of gender parity, which has been an issue that has not been resolved, although it's provided under the Constitution of Kenya, Honorable Speaker. But the question that begs, Honorable Speaker, is if some people or some gender are not eager to run for parliamentary seats or candidates in an election, then what happens of a political party? Can a political party force a certain gender to contest so that to realize this very particular provision, Honorable Speaker? This one, to me, is not very clear. Further, Honorable Speaker, Clause 16 of the bill proposes to insert a new article, that is Article 107A, on the leader of official opposition in the Constitution. This leader of the official opposition should be the person who received the second greatest number of votes in a presidential election. This is a good provision, Honorable Speaker, because it will not only provide vibrance of the House, but it will go also in a wrong way to check the executive or to check the majority side of Parliament, Honorable Speaker. This provision was there, I think, in the previous parliaments, and in the recent past, we have seen the absence of the leader of official opposition, and that absence itself has not made this House to be vibrant as it's usually to be. This is not a new aspect in different jurisdictions, Honorable Speaker, because in the Parliament of Uganda, in the Parliament of United Kingdom, India, Uganda, among others, the leader of official opposition is a candidate who secures the second highest or greatest votes. So I agree with this provision, because it will not only provide vibrancy, but it will also oversight the government in Parliament, Honorable Speaker, more particularly in the National Assembly. Clause 27 of the bill, Honorable Speaker, seeks to amend Article 140 of the Constitution on extension of hearing of presidential petitions. Currently, the Constitution provides 14 days, which are not enough for the judges and also lawyers to make submissions when there is a dispute or when a presidential petition has been filed. The extension of 30 days, this will provide ample time to the judicial officers, those are the judges, to interrogate the matters which will come before them, and from that they will make quite a comprehensive and amicable judgment, Honorable Speaker. Clause 28 of the bill, Honorable Speaker, proposes to insert new articles, that is Article 151A, 151B, 151C, and 151D, to provide for office of the Prime Minister, Deputy Prime Minister, Your Honorable Speaker, and that the Prime Minister be appointed from among the elected members of the National Assembly. Further, Honorable Speaker, National Assembly shall have an opportunity to confirm the Prime Minister nominee, Honorable Speaker. However, this provision, Honorable Speaker, there is a provision that the second nominee for the position of the Prime Minister shall assume office if the National Assembly will not confirm his candidature. Honorable Speaker, this one to me, I think I didn't find it very well, because that means once the first nominee is not confirmed, and then the second nominee is not confirmed, the President has powers to appoint the Prime Minister to assume the office of the Prime Minister without reference to the National Assembly. To this, Honorable Speaker, to me does not appear a good provision, because the role of the National Assembly has been captured under Article 95 of the Constitution of Kenya, and it could have been proper that whichever way the nominee is confirmed by Parliament. Clause 29 of the Constitutional, Clause 29 of the Bill, Honorable Speaker, proposes to amend Article 152 of the Constitution to provide for mixed cabinet with some members from amongst members of the National Assembly. The proposed amendment, read together with Clause 25, Honorable Speaker, seeks further to rename the office of the Cabinet Secretary to that Cabinet, to rename the Cabinet Secretary as the Cabinet Minister. Honorable Speaker, this is a very important aspect of all the things that really impressed me in the bill. This particular provision is a fantastic one. Honorable Speaker, I came with a bill proposing the same. It went through the first reading in December 2019, Honorable Speaker, in this House, and due to Corona virus, Honorable Speaker, it has not proceeded. But I'm happy that when the task force or the committee came to Nyamira, I appeared before the committee and I really submitted what they have captured here. And I'm very happy. This provision will go all a long way to make sure or to ensure that the cabinet ministers are appointed and they'll be members of this House. By so doing, Honorable Speaker, this House will not only be vibrant, but the members of Parliament of the National Assembly will have an opportunity for their issues to be raised and answered on the floor of the House, Honorable Speaker. Honorable Speaker, Clause 32 and 33 seeks to amend Article 154 and 155 of the Constitution to remove requirement of vetting of the Secretary to the Cabinet, as well as the principal secretaries. Honorable Speaker, this is a matter that really needs great attention. Honorable Speaker, it's only yesterday that we were vetting the Cabinet Secretary, the principal secretary. And Honorable Speaker, you saw how the debate went. In my opinion, Honorable Speaker, it could be proper under Article 95 of the Constitution of Kenya that this House is given its role. And among the roles is to vet the principal secretaries as well as the secretary to the cabinet, among other officials or officers who are to occupy various offices in the government of Kenya. Honorable Speaker, while agreeing with some of these constitutional provisions or proposed amendments, I also came across some clauses, Honorable Speaker, which, to my opinion, were not well captured and which does not resonate well with me. Honorable Speaker, the first one is Clause 10 of the Constitution, which seeks to amend Articles 89 and 97 of the Constitution to provide for membership of the National Assembly to increase the number of members elected from constituencies from 290 to 260, Honorable Speaker. Honorable Speaker, I find this proposal, unconstitutional. Reason being, as my learned colleague, Atienda Moro, rightly put it, Honorable Speaker, some proposed constitutional amendments can be unconstitutional if they do not adhere to the process of the provisions of the constitutions provided. Honorable Speaker, on this particular issue, Article 89 of the Constitution of Kenya provides on how the limitation of boundaries can be done. For instance, Honorable Speaker, if you look at the schedule, how these positions or how these constituencies have been made, it does not really make sense, Honorable Speaker. If you look at the 2019 census vis-a-vis the proposed amendments, Honorable Speaker, you will find that in a county like Kwale, whose population is 866 people, 820, it has been given 3 record constituencies. Kisii County, whose population is 1,266,860, has not been given any constituency, Honorable Speaker. Further, Honorable Speaker, Kajiado, whose population is 1,117,840, has been proposed to get 3 constituencies. Honorable Speaker, Migori, where I saw somebody who said is a promoter come from yesterday, with a population of 1,116,436 people, no constituency. Homa Bay, with 1,131,950, no constituency has been given. So the criteria, Honorable Speaker, that was used to arrive at the creation of these constituencies, Honorable Speaker, is questionable. Finally, Honorable Speaker, I also have an issue with Article 41 of the Constitution of Kenya, which seeks to amend Article 168 of the Constitution to make provisions on removal of a judge from office to allow judiciary ombudsman to initiate a motion to remove a judge from office on account of complaints received from the people. Honorable Speaker, this provision in itself is archaic and unconstitutional. It's against the tenets and principles of natural justice, that is the right to fair hearing and also right to be heard. Honorable Speaker, I further submit that Article 10 of the Constitution, as far as the judiciary and the independence is concerned, falls under the eternity clause, which by practice is unamendable. Finally, Honorable Speaker, as I conclude, I could wish, Honorable Speaker, during your time, as you said yesterday, that the issues which were raised on point of order, you will make a ruling or you will deliver the way forward. I could also beseech you, Honorable Speaker, to point out or to make a ruling on the following issues, Honorable Speaker. 1, whether a proposed constitutional amendment can be declared unconstitutional for contravening the provisions of the Constitution. 2, whether the Constitution of Kenya, Honorable Speaker, contains
Honorable Kemosi, please just organize yourself because 15 minutes is a long time. 1 minute, yes. And the staff, please, 1 minute. Light.
Thank you, Honorable Speaker. Second, whether the Constitution of Kenya contains basic structure of the Constitution, also known as eternity clauses, in simple words, an amendability of a certain clauses. Finally, if Chapter 10 of the Constitution, that is the judiciary and its independence, is protected by eternity clauses. Thank you, Honorable Speaker.
So, honor members, again, just remind you, please, so that you don't have to keep asking for 1 extra minute. When you see the yellow light, you have 1 minute, 60 seconds. When the red one comes, you have 30 seconds. Don't rush when you see the yellow, but just know you have 1 minute. The next one on the list is the Honorable Wandai.
Thank you, Wat. Thank you very much, Mr. Speaker, sir, for this chance to express myself on this very important bill. Mr. Speaker, we are indeed...
Members who are placing their requests on the intervention button, please don't go to the intervention button. Just go, because you are doing that, I know you are trying to shortchange the system. To pretend that you are intervening. No. Press the normal contribution button because you have your chance to speak. Honorable Wandai, your minute is restored.
Yeah, thank you, Mr. Speaker. Mr. Speaker, I wanted to say from the outset that this is indeed a historic bill. As many of us have already pointed out, this is indeed the first time as a country that we are amending the Constitution through a popular initiative. It has never happened before, and it is happening now. Mr. Speaker, as we debate on this bill, we must not lose sight of the background. We must understand where we are coming from. Because I see from a number of submissions or speeches, people are forgetting where this country is coming from. Mr. Speaker, it was not something ordinary or something that can just be wished away. That on the 9th of March 2018, 2 persons, one of whom, of course, had rightfully been sworn in as president, and the other one whose victory, of course, he perceived or was perceived to have been subverted, willingly came together to shake hands to save the country. Mr. Speaker, that is not something to be taken lightly. It calls for utmost patriotism for such a thing to happen. And therefore, as we debate this bill, we must remember at all times where we are coming from as a country. Because I see us forgetting very easily. Mr. Speaker, I was honored to serve in the 11th Parliament. And Mr. Speaker, you will agree with me that in that Parliament, we fought throughout. We fought throughout. If it was not fighting inside here, it was fighting in the streets and elsewhere. And we were fighting, some of us, because of lack of an opportunity for dialogue. Dialogue that would have enabled us to carry out these reforms that we are now able to carry out through this process of amending the Constitution under the BBI framework. And therefore, Mr. Speaker, we must pay singular tribute to President Uhuru Kenyatta and Right Honorable Raila Amolo Odinga. We have to. We owe it to them that we are in a position to debate in a conducive atmosphere so as to be able to change the Constitution. Mr. Speaker, constitutional making or changes are never easy things. Even if you are a student of history, you will agree with me that even the acclaimed First Amendment of the US Constitution never came easy. Never came easy. By the time it was being adopted, I think in December 1791, a lot of haggling, push and pull had happened. And therefore, the kind of pushback we are seeing in this process is not unusual, really. It is to be expected. But what do we do as a country? We need to focus on the future. Mr. Speaker, you know, personally, I cut my political teeth, if I may call it so, on the trenches. And I can tell you, not in some boardroom or such like place. Mr. Speaker, I can tell you, it is not easy to get an opportunity such as the one we have currently, to be able to talk as a people, to chart the way forward for our country in the interest of the present generation and the generations to come. So as a parliament, we must seize this moment and provide the way forward for our people. Mr. Speaker, people have been talking about this document, the bill, the BBI Bill. Whether it is perfect or not. Mr. Speaker, let me say this. There is no man-made thing that is ever 100% perfect. It's only God's creation which can be said to be perfect, Mr. Speaker. And therefore, this Constitution, even as we amend it today, there will always be room to amend it again and again and again and again and again. Again, the other question is, does it incorporate everybody's wishes, interests, or feelings? The answer is no. Even me personally, there are things I would have wanted to be in this bill. But they aren't there. They aren't there. And I am sure there are other members here, many of us here, who would have wanted other things to be in this bill. But they are not there. So what do? Do we throw the baby with the bathwater? We can't. That would be irresponsible of us. So it behoves all of us to look at this bill as a first step in our journey to creating a nation that is cohesive, a nation that is at peace with itself. And again, Mr. Speaker, we must appreciate the fact that even the gains, the liberties, the democratic gains that we have attained in this country have always come incrementally. They never came overnight. So we get what we take what we get and we move on, hoping that there will be another time to secure others, Mr. Speaker. Mr. Speaker, one of the most positive things that I can point out in this amendment bill, without necessarily belittling others, is the matter of the enhancement of allocation to our counties. Mr. Speaker, some of us who come from where we come do understand the problems of concentrating power and resources at the center. We understand very well. People have been saying and arguing that what makes it difficult for the current government under the current constitution to enhance the allocations to the counties beyond 15%, or say to 40%. That is an academic argument, Mr. Speaker. Why do I say so? We all know, and we are taught in elementary economics, that resources are always scarce. So when you have resources, you must prioritize. Mr. Speaker, and priorities change with circumstances. So what we are doing is that we don't want to leave this to the whims of whoever is in government, to decide whether to make it 15, 20, or 30. We want to compel him or her through the Constitution that at the very least you must take 35% to the counties. It's only a blind person, as somebody who is not able to see clearly, that can for sure deny that some work has happened in the counties. We know there are problems. We know there are problems of systems. We know there are problems of corruption. But the money that has gone to the counties so far has done something. It is visible. It varies, of course, from place to place. But we must appreciate that this amendment is enabling our counties to get an enhancement of resources from 15% to 35%. The argument of whether the country will be in a position to generate resources is neither here nor there. That is not under our purview. We are making this constitution so that whoever is in power can implement it. Mr. Speaker. And therefore, as we move forward, we must remind ourselves that a constitution-making process is not just a matter of law or legalese, Mr. Speaker. This is a political process through and through, through and through, through and through. So we must always appreciate the fact that we are doing it for a purpose. And we must also understand where we are coming from. And that is why when you see the Speaker, when you hear me speak even out there, I'm speaking very passionately. Because I know that mischief can be played. There is room for mischief in every process. And mischief can be clothed differently, Mr. Speaker. So when we sense that there is an attempt, however minute or little that attempt is, to either subvert or derail or otherwise make this process not move the manner it should move, we must call you out, Mr. Speaker. We must say it as it is, that where we have reached, we only need support of all of us, those of us who mean well for this country, so that we don't engage in sideshows. We don't engage in sideshows, that we focus on the ball and ensure that the country gets the constitution that they deserve. Finally, Mr. Speaker, I'm happy that from here, this bill is heading to the people. It's heading back to Anjiku, as was very eloquently illustrated by the chairman. It is our hope and wish that no more hurdles are placed on the path of this process, Mr. Speaker. And whoever is out there who is listening to us must understand that this is not a child's play, that we shall allow you to bring in sideshows and academic arguments. We want everybody who is responsible to ensure that this process is smoothened and we head to the referendum as quickly as possible, so that Kenyans can pronounce themselves on this bill and we move forward as a country. And those of us who want to mix up issues, who want to bring in matters as relevant as 2022 elections into this process, I'm sorry for you. I'm sorry for you. 2022 will come and pass. But this constitution, God willing, will survive. It will take care of the interests of the current generation and the generations to come. And it's regardless of who will be in power, Mr. Speaker. Mr. Speaker, with those very many remarks, I wish to support in totality this bill and look forward to having it passed overwhelmingly. Thank you, sir.
Member for Madeira. I gave you, you must have, yeah, now.
Thank you, Mr. Speaker. I rise here to speak on behalf of the great people of Madeira, who are my employers and who inform my thinking on a day-to-day basis in whatever I say in this House. Mr. Speaker, we are in unprecedented times. As we speak here about constitutional amendments, there are many Kenyans who have gone without food. There are many Kenyans who have no masks. There are many Kenyans who don't know where they'll get the next meal. There are many Kenyans who are staring at death, not because of COVID-19, but because of hunger. There are many Kenyans who have been thrown out of their houses because they cannot pay rent. And those Kenyans from my constituency are telling me that they would have wanted us to have a special sitting to discuss how they'll be fed, to discuss how they'll pay rent, to discuss about their lives and how they can stay away from death. Those Kenyans, Mr. Speaker, are of the view that in terms of priority, any money available to this country should be applied to get them vaccinated as of yesterday, to protect them from possible death, and to make sure that they have an opportunity to live on and look after their children and educate them. It is for that reason that they tell me, and as I subscribe to that view, that in terms of priority, we have gotten our priorities upside down. Number two, Mr. Speaker, I heard the chairman of JLAC talk very passionately about Wanjiku, about her rights, about her needs, about her powers. I think he has been too busy with this report. He has not had time to travel to the countryside. Had he gone to Muranga, where he's come from, he would have been told that the name of that lady has been changed from Wanjiku to Wagio. Wagio, Mr. Speaker, is that lady who is overburdened, who cannot take an extra burden. She cannot be Wajiko in male, she is Wagio. And that Wagio doesn't want an extra burden. And the implementation of these proposed amendments will add an extra burden to Wagio. Wagio is not breathing. Her back is just about to break. She is staring at death from hunger because of the pandemic and the measures that have been put into place to make sure that people do not infect each other. Again, Mr. Speaker, I have looked at these amendments, and previously I've read the report very keenly, more than 10 times. We have been told that these amendments will address the issues of inclusivity. From what I see, what has been proposed, the offices that are being created are coming from one coalition. There before, governments were formed by coalitions when it was said we didn't have inclusivity. I don't know how these new positions coming from one side of the coalition will address inclusivity. In my thinking, probably naively, I thought that the formation of 47 county governments addressed the issue of inclusivity in totality, so that every county has funds, has its own government, and is able to deal with these unique challenges on a daily basis. Mr. Speaker, looking at the schedule that is detailing how constituencies will be delineated, I want to say from the onset, the people of Nyeri, where I come from, have no business supporting these constitutional amendments because of discrimination. They were discriminated upon because when the BBI proponents went to seek views, they did not tell them to give views about creating extra constituencies. And the formula, and the criteria. Kenny constituency, Mr. Speaker, is 52% of Nyeri County. And I have seen other counties being proposed to have some extra constituencies. Madeira, where I represent, is a very big constituency. And I'm sure if the BBI proponents did not hijack this responsibility and left it to IBC, the people of Nyeri, the people of Kenny, the people of Madeira would have had a great opportunity to appear before the IBC and put up their case using figures and statistics and get constituencies. As it is, if these amendments go through, the people of Nyeri are cooked. They are nowhere. And I must tell the proponents, they'll have a very difficult time in Nyeri. You know, coming to tell people to support something when they feel discriminated. And I talk for the people of Kenya. I have 2 farms there, in Kabaru and in Kakuret. Although my brother and my friend, the Honorable Kanini Kega, is supporting that we go ahead and leave out the people of Nyeri, I must talk for the people of Kenya, where I'm a resident and where I have a farm, that we shall have a problem with this document. We do not want discrimination in this country. We would have wanted to appear before IBC and put up our case, and we would have been heard because we have sufficient reasons to be heard. As it is, we are not heard. So, Mr. Speaker, as it is, I want to tell the Honorable Wandai, it's good. Let the proponents be ready to go to Wagio. There's no Wanjiko. They'll fight Wagio. Wagio is hungry. The late Bob Marley, Mr. Speaker, said, a hungry man is an angry man. as you go to overburden the people in a difficult time when they are dying from COVID, when there are issues, the real issues have not been addressed, when they have no food, when they don't know what to tell their children, and you are going to tell them to create positions for people, to overburden them, you'll find angry people. And angry people are not very nice people. And I wish you the best of luck. Mr. Speaker, I have firm and clear instructions from my employers to oppose these amendments. Thank you very much.
Member for Nyando. You can do.
Sorry? Oh, it's back. From the outset, Honorable Speaker, let me thank you for this opportunity. And together with the proponents of the BBI Bill that is before this House, I join them. Honorable Speaker, we as a nation must firstly backtrack and get to understand how we ended up here. The country, after the 2017 elections, that was marred with a lot of illegalities and irregularities, if the Supreme Court decision is anything to go by, did invite a lot of divisions amongst the Kenyan people. Some of us who still believe to date that we were denied our victory took a different tangent that was not in sync with the peace and tranquility that a nation should have. But through wisdom, our two principles came together, barring their differences and reaching a common goal to have this country be united and once again move as a one unitary society. Honorable Speaker, that is what gave birth to the handshake and consequently the BBI as a document. And if there is anything that the handshake that brought about peace will be remembered for, is this BBI that we intend to have the Kenyan people through a referendum add their weight and their voice so that we can once again midwife a constitutional amendment. Just like 2010, we are once again in a constitutional moment. And Honorable Speaker, we were not born and created for constitutions. Constitutions are just but guiding principles on how people can transact and can relate with each other. And if there are areas where the Constitution does not act and work for us, it is our responsibility to make necessary amendments. No constitution the world over is cast on stone. And a time such as that has emerged, and we are, as Kenyans, coming up to make changes in areas where we feel the shoe pinches. We have worn this shoe for the last 11 years. Even the Constitution proposes 8 years to carry out amendments. We are at 11 years now. So we are actually time-barred to make necessary changes that work for us. But as is democratic, the naysayers must always be there. We will listen to them. And we will not have any given time when all legislative pieces will be presented, adopted, and passed. Otherwise, this House will have no work. And for those who think that their visions and their views have not been captured here, there will be a second amendment, there will be a third amendment, there will be a fourth amendment, just like the United States of America are beyond their 21st amendment to date. So this is not the last time. Mr. Speaker, we have had an elaborate process to get to where we are today. And the Kenyan voices have been heard, and that is what has been put in this document. So the views that are constantly heard, that certain individuals are forcing in the throat of Kenyans a document, that is not true, Honorable Speaker. Lots and lots of public participation exercises were carried out. People presented their views from across width and breadth of this nation, and those who are promoters of this document did not go out there to come up with their own views, but they collected Wanjiku's views. And therefore, we, as a people who have been given the mandate to lead, must always tell the truth that this is a document that is reflective of the wishes and aspirations of the Kenyan people, Honorable Speaker. We know that the end game here is a referendum. I know certain views have been advanced that after this, the document can be taken to the house on the hill and be assented to, and it becomes law. That can never be so, and that cannot stand. The Kenyan people must have their voices heard through a referendum. And even the naysayers will be heard. It is not so automatic that once it appears before the Kenyan people, it must pass. No. Kenyans will be given an opportunity to express their views on this document by way of voting. So for those who think that this is not in sync with their desires, they can vote no, and that is still democratic. Some of us, including myself, who are ardent supporters of this document, will vote yes. And up to now, we believe that we have the majority. But that does not mean that we shall sideline the minority. We will hear you, and we shall give you another opportunity in the nearest future as we come up with our second amendment so that those views can also be incorporated, Honorable Speaker. Amendments are always carried out to reorient people's lives. It is not something that is coming from the blues. And these are areas where we have identified, and the voluminous bill has gone in depth to try to dissect fundamental issues that bedevil this country. And one of them is divisive elections. No country can develop if each and every 5 years they have to be subjected to rounds of violence. No investor, domestic or foreign, will put his capital investments in a country that is staring at violence and destruction of property every 5 years. That can never be so. So we are trying the much we can under the circumstances to fix these emerging issues that would prevent this nation from making rapid flights on its economic progress. And we know that with this document, Honorable Speaker, we are on the right path. Honorable Speaker, the process must inevitably have supporters and non-supporters. And that is why people meet at the ballot to express their views, Honorable Speaker. One fundamental thing that I will strive to support this bill to the hilt is the mere fact that additional funding will be going back to our counties. 35% from 15% is monumental amount of money, and that is going to support lots of devolved functions at the counties. The hospitals will be built, there will be adequate medicine, our roads will be worked on, water will be provided, and I come from a constituency where water still becomes a problem, even though on the flip side, we have flooding every year. So if the county government will be getting additional funds to provide water services, then places like Nyando constituency will confine into history books this waterlessness that we eternally have up to now. And Honorable Speaker, what I would have suggested, even for the Senate, together with the Council of Governors, and all the stakeholders in the devolved functions, including the Ministry of Devolution, is that the devolved funds should take the tangent of the CDF funds, where monies can only be disbursed when they are already plugged onto projects. But giving governors and county assemblies monies that still go there and they have to now sit down and decide which direction money goes, that is why we have pilferages, Honorable Speaker. it is very difficult to pilfer national government CDF because it is tied to projects. And that is why all over the country, wherever you go, you see nothing but CDF-funded projects. And how I wish that CDF would also be increased from 2.5% to even 5%, so that we can address the plight of our schools, the plight of our chiefs and their assistant chiefs, together with the plight of the police who carry out our security arrangements down there. And Honorable Speaker, the Youth Commission, which will be addressing the concerns of our youths from the grassroots. And you know, it is a time bomb, and this has been said severally, that these youths without any tangible income will one day become disastrous to this country. And the Youth Commission will be able to have all the CVs of the youths, if they have any, try to put them into jobs, address their problems as they emerge. Those who want to do businesses will be given monies so that our youths can as well be engaged. And this is the productive lot of our society that we cannot wish away. On the same, Honorable Speaker, I'm very happy that there will be a moratorium spread on the Higher Education Loans Board that is expended to students in various universities and colleges. 7 years upon graduation is ample time to put their houses in order so that when they start paying back these monies to the government, they shall have stabilized and they will not be hard-pressed on meeting this obligation, Honorable Speaker. The ward funds, which will be under the purview of the members of county assemblies, will also go a long way in addressing issues at the county, at the ward levels, and this is something that we all stand in solidarity to support, Honorable Speaker. Honorable Speaker, there will not be such a moment such as this. Constitutional making process is not a one-stop shop and is not an easy thing to achieve, especially when you have people who have gone through an electoral process and have fought tooth and nail in order that they can seize the power. And this is the only moment that we have seen protagonists coming together to address the problems that have emerged in this nation for way too long. It is not about Right Honorable Raila Odinga, and in fact, he has sacrificed it all to have this country have a semblance of peace. It is not about President Uhuru Kenyatta. It is about the Kenyan people addressing their issues of concerns so that once again, the country can move forward as one united nation. I thank you, Honorable Speaker, and I support.
Honorable members, I want to reiterate what the Speaker had earlier communicated to the members, that on this motion, we shall strictly follow the LOTA. And if you want to know where you are, you have the liberty to go to the clerk's screen and see where you are. I will strictly follow that as the Speaker had earlier communicated. Regardless of whether 2 or 3 people come from one side, I will follow this list. Honorable Masara Francis, member for Suna West.
Mr. Speaker, you'll allow me, with my 15 minutes, to remove my mask because everybody is putting on the mask. Mr. Speaker, thank you for giving me this chance. And as well, I want to thank the people of Suna West for electing me so that I can be part and parcel of this historic moment of changing the Constitution for prosperity. Mr. Speaker, the first and ever popular initiative which has happened in Kenya is this one, Mr. Speaker. Because way back in 2017, over 16 million people voted for the 2 brothers. That is His Excellency Uhuru Kenyatta and His Excellency Raila Amolo Odinga. They delegated their powers and authorities and rights to them to speak on their behalf. Therefore, Mr. Speaker, when they decided, as people who competed and, on the presidential election, to sit together and agree on matters of this country, Mr. Speaker, I can say that is a big blessing. Mr. Speaker, reforming or changing constitution has never been easy anywhere. And those who believe that the status quo is benefiting them will always come out in opposing whatever the people want to get. Mr. Speaker, therefore, I want to say that the BBI initiative and the BBI Amendment Bill of 2020 is what has really brought a lot of good things to us, Mr. Speaker. Mr. Speaker, I want to say that in this proposed amendment bill, in clause 11A, shared prosperity, Mr. Speaker, that clause is going to help us as a country, because the state is now is mandated in the Constitution to promote the blue economy. Mr. Speaker, I'm coming from the lakeside. Therefore, it means the fishermen, the people around Lake Victoria coming from Nyanza and Migori in particular, will be taken, their interests will be taken care of. Mr. Speaker, I want to speak also on clause Mr. Speaker, I want to speak on clause 51. Clause 51, Mr. Speaker, clause 50. Clause 50 is going to amend the Constitution so that the percentage which was being given to the counties from 15% to 35%. Mr. Speaker, my background, I came from the local government. We were receiving small money called Latif, and that Latif really changed the areas where councillors used to work well to enhance the development of the people. Mr. Speaker, if you look at the CDF money now, the CDF money has really improved development in all areas in Kenya today. In each constituency, if you walk around, you'll see a signboard of money, a project which has been done by CDF money. And therefore, Mr. Speaker, the Constitution, if you look at clause 11, also talks about how the people messing with the public money are going to be penalized. Therefore, if the money for counties increase from 15 to 35%, Mr. Speaker, the issue of inclusivity is going to be realized. The inclusivity in the sense that each and every area, be it in Turkana, be it in Mombasa, be it in Migori, be it in Baringo, each Kenyan is going to enjoy the fruits of the cake in terms of development. Mr. Speaker, as well, I want to talk about clause 54 on Ward Development Fund. Currently, as it stands, the ward reps are at the whim of the governor. If you are not singing, a good tune which the governor entertains, your area is not being allocated money. But now, moving forward, Mr. Speaker, each ward rep will receive 5% of the total amount money allocated to their counties. Therefore, it means, Mr. Speaker, that each area, each village will receive money from the national government, through county government, through Ward Development Fund. Mr. Speaker, if you look at the same clause, which is going to amend section 207A on Ward Development Fund. With Ward Development Fund entrenched in the Constitution, the MCAs will do their oversight role because they'll be able to pinpoint areas where the governor is not doing well without necessarily being punished for doing that. Mr. Speaker, I'll also speak to clause 51. Clause 51. Mr. Speaker, the same clause talks about sorry, Mr. Speaker, clause 63. This is where of my interest most. The clause is trying to amend section 237A and a creation of youth commission. Mr. Speaker, for the first time, in the history of this country, we are going to create an independent commission which is going to cater for the interests of the young generation of this country. Youths forms the bigger percentage of the population of this country. But when people are discussing about development, about interest, nobody is thinking about the youth. So therefore, for the first time, the clause 263(4)(b) talks of mainstreaming of the youth perspective in planning and decision making. For the first time, the interests of the youth is going to be mainstream so that they participate actively and independently in decision making. Section C of it talks of the Commission will advise the national and county governments on design, implementation, and evaluation of policies and programs to secure sustainable livelihoods for the youth, Mr. Speaker. Youths now, as we talk, they don't know how to live because they don't see hope. But when this bill is passed, Mr. Speaker, the county government and the national government will be forced by the Constitution to look on how their livelihood can be sustained. Mr. Speaker, I want to remind this country, that, this parliament, women have their commission which support them. People living with disability have those who support them. Teachers have those who commissions which support them. But for the first time, youths are going to be given opportunity to be part and parcel of decision making. Mr. Speaker, if you look at the composition of that commission, it is talking of 4 members must be youths. It means out of the 6, the majority will be youths. That means decision which is going to be made in this commission will favor the youth. Mr. Speaker, I support this promotion because this particular bill, because it is going to promote the preservation and dissemination of Africans' morals, traditions, and cultures among the young people. Mr. Speaker, this bit is very important for this country. As we speak in the current generation, many youths don't understand their cultures. Many youths don't understand African cultures. They have been westernized to an extent that they don't know what belongs to Africa. And now in the Constitution, if we pass this bill, Mr. Speaker, the Commission is going to ensure that they'll promote and preserve and disseminate. There are 3 things there. They'll promote, they'll preserve, and they'll disseminate information related to African culture, Mr. Speaker. Mr. Speaker, as we talk now, if you ask current generation why somebody need to respect the parent, they don't understand. Mr. Speaker, therefore, I want to urge members that as we move forward, as we make this constitution, we must understand that it is for the current generation and the generation to come. Opposing it is not a problem, because even I'm a Christian, Mr. Speaker, in the Bible, for things to work the way they are working now, it forced God, who is very merciful, to eject Lucifer from heaven and send him to this country we are now on earth, so that things can be put in place for heaven to be real heaven. Therefore, those who are opposing these things, we encourage you, but I know, Mr. Speaker, when President Uhuru Kenyatta and Raila Amolo sits together, my friend, nobody can defeat their initiative. That's one assurance I know. I discussed with the people of Sona West, and they told us that so long as Raila Amolo Odinga and Uhuru Kenyatta are supporting the initiative, they are going to vote for this particular, when it comes to referendum, they are going to vote 100% so that they can receive money for development, so that the youth can be, the youth's interest can be protected, so that World Development Fund can be protected. But as well, Mr. Speaker, I'm happy that from the mood I'm seeing, very few people are going to oppose, because Sonkok talked with me earlier today and told me, Mr. Masara, Honorable Masara, I'm not going to oppose this thing because youth's interest is catered for. The rest of the things we'll get one day, one time, because we are going to nominate, for the first time, Sonkok is going to contest and maybe get to be second so that he can be nominated. Thank you, Mr. Speaker, and I support the bill in entirety the way it is. Thank you, Mr. Speaker.
What is it? What is it? What is it? Honorable Masala, you are done? You are done, okay. Next in the list is Honorable Sotsi Godfrey.
Thank you, Mr. Speaker. Mr. Speaker, thank you for the opportunity to contribute to this very historic motion of amending the Constitution of Kenya for the second time, Mr. Speaker. Mr. Speaker, first I will want to start by thanking the committee, the Joint Committee of Justice and Legal Affairs of both the National Assembly and Senate for the good work. Mr. Speaker, I've had an opportunity to go through this report, and this is one of the best reports that I've ever read in this House, Mr. Speaker, because they have tried to capture every small detail on this bill. They have tried to dissect every issue that required to be dissected. And I also want to say that Parliament managed to assemble what I would call a committee of experts. Because in this joint committee, Mr. Speaker, we have around 28 members. And out of that, 18 members are lawyers of huge reputation in this country. So whatever report they have given us, Mr. Speaker, it is a report that is competent, that is a report that is very professional, and that it is a report, in my own view, I think is a report that is good for this House. And I would encourage fellow members of Parliament, please take your time, read through this report, so that the contribution we make in this House, it should be informed by this report and not what other people are writing outside there. Mr. Speaker, the second thing that I want to put across is that what we are dealing with here, Mr. Speaker, is a constitutional issues reflected in the BBI report. We still have legislative issues, policy and administrative issues, which I want to ask the House to expedite on these other aspects in the BBI report, so that particular bills that we are supposed to deal with, they are brought to this House, and we finalize matters to do with BBI as soon as possible. Thirdly, Mr. Speaker, you know, Mr. Speaker, I have been among the members who have been saying Parliament cannot be a bystander. Parliament cannot be a rubber stamp. But reading through this report and listening to the contribution of the mover and the seconder, I am convinced, Mr. Speaker, that there is no room to amend this bill. There is no room to amend this bill. This bill belongs to the people of Kenya. Our role under Article 257 is to pass it or reject it. And then it will go to the people of Kenya to make a decision. There has been also a concern raised by some people as to whether this bill is properly a popular initiative. Mr. Speaker, if you read through this report, it gives a very good historical background of where we started from. We started with the divisive election of 2017, where we had two leaders who got a cumulative votes of 15 million Kenyans supporting them. Then these two leaders, in their own wisdom, decided to shake hands in the handshake. And that handshake had an agreement signed, a joint communique between the two. That is where we started. So for those of us who are saying that this does not qualify to be a popular initiative, I think they are not with us in this country. Because we have two leaders who are voted for by Kenyans, 15 million votes. Those 15 million votes were people of Kenya. That is where the legitimacy of this bill is coming from. The people of Kenya. So this is a people initiative, and our role is to pass this bill to the people in a referendum, and the Kenyans will make their decision known. Another issue, Mr. Speaker, I want to raise is the issues that we have been hearing in the media. Mr. Speaker, last week we were fed with information that some county assemblies passed bills which were not authentic. Mr. Speaker, if you read this report, it is very clear that the bills that went to the county assemblies and they were passed were authentic, and